Alright, today we are starting off with Chapter 3, the Constitution. We're going to look at the 6 basic principles of our Constitution, and really what it's all about is the fact that our framers of our Constitution felt that having less is more. That the less they stated, the more our Constitution could actually mean. So we're going to look at the 6 basic principles of it, the 6 basic kind of themes of our Constitution. And the first is popular sovereignty. And popular sovereignty, if we break it down, we already know what sovereignty is. Sovereignty is having power to make enforce your own laws. And popular isn't really popularity. Instead, it actually is about people. And so popular sovereignty is that the people are the only source of governmental power. Our government can govern only with the consent of those that it governs. So if the people were not the actual true power behind it, then we wouldn't have the ability to say who's going to be in control. We wouldn't have the ability to change our government as we see fit or as necessary. The second is limited government. And limited government is where the government can only do those things that it has been given the power to do, such as those things that are in the Constitution. If it's not in there, then they shouldn't be able to do those things. It also says that government must obey the law also. They aren't exempt from it. They don't get a bye. So the third is separation of powers. And we see that in our 3 branches of government. We have the legislative body, which is made up of Congress, the executive, which is headed up by the president, and the judicial branch, which is the court system, and the highest court is the U.S. Supreme Court. The fourth is checks and balances between those 3 branches. We do have equal and independent branches that work with each other. And if you look in your textbook on page 58, there's a chart that shows you the checks and balances of the branches on each other. And we're going to go through a couple of them. First, we're going to start with the judicial checks. On the legislative branch, the judicial branch can declare acts of Congress to be unconstitutional, which is a way that it can check its power. The judicial check on the executive branch can include things like declaring presidential acts unconstitutional. Next, we're going to move to the legislative branch, and the legislative branch has checks as well. And legislative check on the judicial branch is that they can impeach judges. They can also reject or approve the appointment of judges to their office. The legislative check on the executive branch is that they can override a veto with 2/3 vote, and they can also impeach the president. And then finally, the executive branch. The executive branch has checks as well. And the executive check on the judicial branch is that it appoints judges to the Supreme Court. And the executive check on the legislative branch is that it can veto laws, and it can recommend legislation that could go before Congress to be approved. So that is how they balance each other in power. And so that checks and balances is very, very key to our government and how it functions. The fifth of the basic principles is judicial review, and we kind of covered that in the last unit. But judicial review is the power to decide whether what government does is in accordance with the Constitution or not. So they're looking for something to be unconstitutional. And if it's unconstitutional, then it's illegal. It's null and void. They can't do it. The sixth of the principles is federalism. And federalism is that division between the central government and then the local or regional governments. And in our case, we have the national government or the federal government. We have the state governments. And then we also have the local governments like your county or your city governments. So we actually have multiple layers. But typically federalism is at least a division of 2 layers or 2 separate entities. But we have more than that. So like I said, our framers felt that less is more, and so they didn't really put a whole lot in the Constitution. And so what they did do is they created a process for formally amending the Constitution to make it so that it does work for the people. And so it's called the amendment process, and an amendment is a change to the Constitution. There are actually 2 methods of proposing one, and then there's 2 methods of ratifying it or approving it. The first method is that it can be proposed by 2/3 vote in both houses of Congress, and then it needs to be ratified by 3/4 of the state legislatures. So it goes through Congress first, and then it goes to each of the state's legislatures, to the state's governing bodies. And that has been done for 26 of our 27 amendments. Amendment 2, or Method 2, is proposed by a 2/3 vote in both houses. So it's the same proposal method, but it's ratified by conventions in 3/4 of the states. And that was done for one of the amendments. Now, a difference between the state legislatures and a state convention is that in the state legislature, it's people that are elected to govern the state. In a convention, anybody can come in, or they can give out tickets for who can come in to vote. So, or interested parties, or whatever it is, but the people actually have the chance to vote on that instead of just elected officials. So currently there are 27 amendments. The first 10 are called the Bill of Rights. The 13th, 14th, and 15th are called the Civil War Amendments because they were passed right after the Civil War. You're going to need to know the first 10, the Bill of Rights. Number 1, freedom of speech, religion, press, assembly, and petition. Number 2, the right to bear arms or to have weapons. Number 3, the right to not quarter, or it deals with quartering of soldiers, which basically means that we don't have to house soldiers in our own homes. Number 4 deals with searches and seizures, so having to have a search warrant. Number 5, a lot of it deals with due process, and due process just means that things have to happen in a certain order. So you don't have to serve jail time before you actually get sentenced for your crime or before you have a trial. Number 6 is the right to a speedy trial. Number 7 is a trial by jury. Number 8 deals with excessive punishment. Number 9 is giving powers to the people that aren't specifically mentioned in the Constitution. So things like the right to live where you want, the right to an education, the right to get married, to move from state to state. So there's a lot of different things involved in that. And then number 10, the power of the states, and that reserves powers to the states that are not given to the national government. They're called the reserved powers. Now, our Constitution also allows us to have informal amendments, and an informal amendment is the process by which a lot of changes have been made in the Constitution without actually changing the written word. A regular or a formal amendment changes the written word. An informal amendment does not change the written word at all. So there are 5 ways that we have informal amendments. The first is just basic legislation by Congress. Congress kind of fills in the empty spaces left in the Constitution. It adds the details, it adds the meaning by passing laws. And so the framers had worded the Constitution vaguely on purpose. They did not want everything to be completely written down. So, for example, setting up the judicial system. The Constitution doesn't talk about how to set it up. It doesn't say that there needs to be a Supreme Court or local courts or anything like that. That was completely done through legislation. Setting up a banking system. The Constitution talks about the national government being able to coin money and to borrow money and to give out loans, but it doesn't talk anything about creating the banking system of the federal government at all. So again, that's something that was passed by laws. So that's the first way. The second way is through executive action. These are things that the president does. And for example, the president is commander-in-chief, but only Congress can declare war. So it kind of ties the hands of the military because he can't give orders without Congress declaring war or giving approval for stuff. But the president's able to work around it through some legislation and through some executive powers that he has. For example, the executive agreement. An executive agreement is a pact or an agreement made by the president directly with the head of a foreign country so that they work together. This is different than a treaty. It's not the same as a treaty because an executive agreement does not need to be approved by the Senate, but it's still legally binding. So it's a way to work around the system. It's a loophole. The third way is through Supreme Court decisions. Now, the Supreme Court, remember, looks at laws and says if they are constitutional or not. So it interprets the Constitution. And the Supreme Court's job is to interpret and apply the Constitution. Look at what the works of the framers and like the Federalist Papers and those kinds of things, and figure out what were our founders thinking. Is this something that they would have approved of? Is this a power that was given to the Constitution and to the U.S. government? The fourth is the activities of the political parties. The Constitution does not mention political parties anywhere in the document because they actually wanted to avoid having political parties. And so things like the nomination process of having the convention to nominate the president and the vice presidential candidates, they're based on the Constitution, but they are not in that process is not given in the Constitution. That's something that the parties themselves created, of getting the nominating conventions and the caucuses and the primaries and all of that stuff. That was all created by the political parties. The fifth is custom, and custom is just a tradition. And we have multiple customs that have come down through us that through the decades, through the centuries. And for example, the first one that comes to mind is the cabinet. In the Constitution, it talks about the president having advisors, but nothing is formalized as the cabinet today. And the cabinet is an advisory body to the president. And it started out with George Washington, our first president. He had a cabinet of 4 members, and he had basically made that decision that he's not going to be able to make informed, educated decisions on every topic. So he brought in the most knowledgeable people that he knew to advise him and to help him out. And so that has grown throughout the years, and that now today we have 15 executive departments within the cabinet, and they each specialize in a certain area. So that is a way that we have seen custom become almost law in a way. The next kind of custom is, for example, let's say the president dies while he's in office. Well, it's a custom that the vice president immediately takes over and becomes president. Now, the Constitution doesn't say that the vice president becomes president. It just says that he takes over the duties and powers of the president, but not the actual office or not the actual title. So what's the difference? Well, really the only difference is about $250,000 a year. It's a difference in paycheck. So traditionally what has happened is that the vice president becomes president and they get a new vice president. And so that's really the only difference that is between them is the paycheck. But people are more reassured by having an actual president rather than a vice president who takes on the duties and powers of the president. Another example is the no third term tradition. George Washington, again, set this when he was president. He said 8 years is enough, don't need to have more than that, because there's a possibility that people could become corrupt and abuse this power. And so that tradition stayed until FDR was elected. FDR broke it by running and winning a third term and a fourth term. So he completely broke that tradition. However, that tradition finally became formalized. It became a formal amendment with the addition of the 22nd Amendment, which was added in 1951. And again, the reason why that we set that was because we don't want our presidents to become too power hungry, too full of themselves, and possibly abusing their power. So the next video the next lecture we'll be looking at federalism and how that works in the U.S. Constitution.